soon as possible. And this is echoed by the Conference of Rulers, which is also requesting for the same thing to happen. So here it begs the question on whether or not the Prime Minister is obliged to adhere to the request made by the Yang di-Pertuan Agong or His Royal Highness in this, during this time of pandemic, and to really bring the emergency to an end. So here, before we start, that's a little bit of introduction what's going on. Before we start, can we just all of us begin with reciting Umul Kitab Al-Fatihah? All right, thank you. Okay, to those who just joined, welcome to this event again. All right, so let me just introduce the moderator as well as the list of panelists that we have today. All right, let's start off with our moderator. Moderator for today's event is Professor Dr. Nik Ahmad Kamal Nik Mahmud. He is the coordinator for this CANGGIH research cluster. He is the former dean of AIKOL, as well as the former deputy rector of student affairs of IIUM. And of course, he has been teaching constitutional laws as time immemorial, Prof. And he has a vast experience, especially in constitutional law. Has been having published many articles, many books on same topic in the same area. And now let's move on to the panelists. We have 3 panelists today with us. The first one is Professor Dr. Farid Sufian Shuaib, the Dean of AIKOL, the current Dean of AIKOL, and of course the constitutional law expert, having teaching constitutional law for more than 20 years, and of course published so many articles and books in relation to constitutional law. And the second one, we have Dr. Nur Hafizah Muhammad Badrul Afandi. She is the current head of Department of Civil Law, and of course the constitutional law expert as well, having more than 20 years of teaching experience in the topic of constitutional law, as well as especially with regards to the law on citizenship. And the last one, we have Associate Professor Dr. Khairil Azmin Mukhtar. He is the former head of Department of the Civil Law, and as well as the constitutional law experts, having vast experience in teaching constitutional law and publish articles and books in relation to constitutional law, as well as appeared in many TV programs as well as radio programs, in especially discussing on this topic on constitutional law. So without further ado, I would like to pass the floor to Professor Nik Ahmad Kamal Nik Mahmud to start the discussion. Thank you.
Thank you very much, Dr. Syahadawati. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Very good evening to everyone. Thank you for the very brief introduction to all of us here. I would like to thank the research cluster CANGGIH, Constitutional Administration, Good Governance, Integrity, Human Rights Research Cluster of Ahmad Ibrahim Kuliah of Laws, big of a mouthful. This is perhaps our activity. I would say this is our first activity for the year, even though, during the MCO anyway. But this has been a very interesting week so far, since the proclamation of emergency in January 2021. We have seen a flurry of activities. We have seen also so many debates on this issue about who can proclaim emergency, and now that we have also been debated, we have been debating on the issue of whether Parliament can sit and who can convene Parliament, and so on and so forth. But of course, the focus of tonight's discussion will be on these issues, inshallah. And we have able and experienced speakers tonight. We have Prof. Farid, who is also the Dean of the faculty, who has been teaching constitutional law and has written a book on constitutional law. We have Associate Professor Dr. Khairil Azmin, who also has been teaching constitutional law for a long time, and he has been appearing in radios and television, and also giving comments in newspapers about constitutional law issues. We have also our head of department of the Civil Law Department, Dr. Nur Hafizah Badul Afandi, who has also been writing quite a number of pieces on constitutional law matters, especially on citizenships. So how we going about tonight's program? First, we have 4 sessions. The first 3 sessions with the panelists, and then the 4th session will be question and answers. And I would like to invite question and answers from the members who are in the Google Meet. If you want to ask questions, please state your name and your affiliations. And those who wants to also put question in the chat, you can do so as well. We hope that we can finish by 9:30. We have the panelists to speak around 1 hour from now. And I will be inviting each and every panelist during the rounds, and then we can have a bit of more discussion after that, because the panelists will be presenting on specific topics which I will be giving them to speak about 10 minutes. And after that, I will invite also other panelists to also respond to, maybe also make comments on based on the presentation of the panelists. So without further delay, let us first invite Professor Dr. Farid Sufyan, who has his LLB honors from IIUM, and he has also his master's from Queen Mary College, University of London, and his PhD from IIUM as well. He has published on administration of Islamic law in Malaysia, and he has also written on the constitutional law of Malaysia case and commentary. He has been speaking in seminars in countries like England and Turkey and Indonesia, and of course he has done quite a number of research and publication on issues of Malaysian legal system and also constitutional law matters. And he was awarded a Quality Research Award in 2005, and also Hadiah Karya Kencana from Science Social category from Dewan Bahasa and Pustaka in 2011. So Prof. Farid will be speaking about a general overview of the powers of the Yang di-Pertuan Agong, and probably also will be touching on powers of the Yang di-Pertuan Agong in relation to proclamation of emergency. So without further delay, I would like to invite Prof. Farid.
Bismillahirrahmanirrahim. Thank you, Prof. Ahmad Kamal, for the introduction. Assalamualaikum and good evening, everyone. So today we'll be discussing on Yang di-Pertuan Agong in particular and constitutional law in general. And I've been tasked to give an overview of the topic on the Yang di-Pertuan Agong. As first, Yang di-Pertuan Agong is if we want to look at the federal constitution, is the supreme head of the federation. So he is the head of state, as opposed to the prime minister being the head of government, and he's elected among the 9 Malay rulers through the Conference of Rulers. So although YDPA is created through the federal constitution, so this creature of the federal constitution, but the basis of its existence, we have to relate it back to the Malay rulers. So if you want to look at the history of Yang di-Pertuan Agong, we need also to look at the status and privileges in reference to the Malay rulers. So that's just a general introduction on the Yang di-Pertuan Agong. So what's the position of Yang di-Pertuan Agong? It's created by the federal constitution. It's included in one of the terms of reference for the commission entrusted to draft the constitution for an independent federation of Malaya. So it's from beginning there is provision in the term of reference to create a Yang di-Pertuan Besar among the Malay rulers. I suppose reference may be made by the system in Negeri Sembilan uh, in having election of the head of state. And uh, it, he is a constitutional monarch. So what does it entails as constitutional monarch? Um, First, the obvious thing is that his function and powers are subject to the constitution. He does not have absolute power. However, talking about this, probably if you look at the history of Malay rulers, some may argue that Malay rulers never had absolute powers because they have always been guided. They are always being guided by law and custom. So in that sense, probably it's not such a drastic thing to say that the Yang Tuan Agong is not an absolute ruler. And if you look at the federal constitution, Yang Tuan Agong have to take an oath of office. And if we look at the content of the oath of office, among the content is that he has to govern with justice according to law and constitution, to protect the religion of Islam, to uphold a peaceful and just government. So those are the basic things under the oath of office of the Yang Tuan Agong. In taking the position as Yang Tuan Agong, he had to make those declaration. And of course, if you want to discuss about the constitution, usually would be probably beneficial to look at the different organs of government. You have the executive, legislature, and judiciary, and we look at the. If you look at the three organs of a government, you can find the Tuan Agong in the three organs of government. For instance, for executive, it is said in the federal constitution that the executive authority is vested. Executive authority of the federation is vested in the Yang Tuan Agong. That it is exercisable. The executive authority is exercisable by Yang Tuan Agong or the cabinet. And in exercising his function, this is probably the one of the primary thing to consider in discussing about the powers and so on. That Article 40 mentioned that in exercising his function, he has to act on advice of the cabinet or a minister acting under the general authority of the cabinet, unless provided otherwise in the constitution. So that's the main provision, I suppose, when we discuss about what the extent of how he should exercise his power. That Article 40 mentioned in exercising his function, he has to act in accordance with advice given by the cabinet or a minister acting under the general authority of the cabinet. And he's entitled to any information concerning the government, meaning if you want to advise him, then he may ask information, I suppose in particular relating to advice. If you advise him to do certain things, we may consider later on whether he has any option or not, but certainly to support the advice or to clarify on the advice, he may request for information for him to make a decision. And I suppose then the constitution clarified that if he has to act on advice, basically he has no option to accept the advice given. So, and that's the clarification made in the federal constitution. One may say that it is superfluous because it's clear that if he has to accept to act on advice, he has to accept the advice. But looking at the practices, probably it may or may not be that a convention has a rise on those practices. So the legislature may have decided to make clear what should be the position, what's the value of the advice given if he has to act on advice, and it's stated under clause 1A that if he has to act on advice, he shall accept the advice and act in accordance with the advice. Not to say that he has to act on advice in every circumstances. Only when the provision says he has to act on advice. So in other words, If the provision provides the power for him to act in his discretion, advice may be given, but he is not bound to act in accordance with the advice. So that's under the executive, which most of the convention would be. The legislature, we can find also the Yang Tuan Agong, because one of the component of the parliament at the federal level, the legislature at the federal level, is the Yang Tuan Agong. That parliament consists of Yang Tuan Agong, Dewan Rakyat, and Dewan Negara. And the function of Yang Tuan Agong in particular here is in giving assent to the bill. Again, there's an issue here. Either he has to act on advice or he has discretion in assenting on the bill. If you have time, probably we can go into that a little bit. In judiciary also, he has a position. In particular, he is the appointing authority of judges on the advice of the Prime Minister after consultation of the Conference of Rulers. This we have also case law on this, which probably make clear that in exercising this power, he has to act on advice of the Prime Minister. Even to a certain extent, in the case law, it seems that, well, the judges were emphasizing, well, basically he has to do, he has to give effect to whatever suggestion or recommendation made by the cabinet or the minister or the Prime Minister in this situation. Okay, so that's looking at the organs of government. Before I end, because I have only 10 minutes, probably looking at the acting on advice, if we can go a bit detail on that. What are the matters? One usual example given on the appointment of ministers. Prime Minister to advise him, YPA to appoint ministers. Dismissal of ministers. That's also there's case law on that. Then the issue, probably the current issue on summoning parliament. We have that under Article 55. Yang Deputy shall summon parliament. But please bear in mind, probably I don't have time to discuss this now. Please bear in mind, we have the Emergency Essential Powers Ordinance 2021. What section is that? Section 14. That basically effects of deleting, well, not deleting, to not giving effect Article 55. That Parliament may be summoned on a date as the Yang Tuan Agong thinks appropriate. That would be interesting. What will be the effect of this? If summoning Parliament under Article 55 is on advice, what about a date as the Yang Tuan Agong think appropriate under Section 14 of Emergency Essential Ordinance 2021? Similarly, at the state level, under Section 15 of the Emergency Ordinance, not giving effect to the provision in the Federal Constitution and the provision in the State Constitution, the date to summon the State Legislative Assembly is on the date as the Yang Tuan Agong think appropriate after consultation with the respective ruler. So the YDPA thinks appropriate is not present under Article 55. What would be the effect? If Article 55(1) on advice, what about Section 14 and Section 15? And of course, another thing interesting to consider, the fact that Article 40 mentioned about acting on advice on a function under Federal Constitution and Federal law. Would Emergency Ordinance 2021 considered as federal law? Is promulgated under Article 150, not an act of Parliament passed by Parliament. Okay, another, before I end, just to compare acting on advice, we have acting on discretion, appointment of Prime Minister, withholding consent of request dissolution. So you have summoning Parliament, Article 55, but then it's clear that there is discretion in withholding consent to request for dissolution of Parliament. Discretion for calling on meeting of conference or reviews regarding privileges. And you have power of pardon, for instance, Article 42. What about if there's no clear indication in the provision whether act on advice or discretion? For instance, on assenting bill, for instance, because although shall assent the bill, but there is Article 66(4)(a) that says in the event it's not assented, it becomes law. So it, in a way, the federal constitution itself poses the possibility of the bill not being assented. So how you reconcile these two provisions? And of course, under 150, if he is satisfied, also what's the significance to say that YDPA shall proclaim, Yang Dutan Agong shall proclaim may proclaim the emergency if he is satisfied that there's grave condition and all that. So if it's unclear, two possibilities. One, we can refer back to Article 40, Clause 1, that says that if he has to act in performing his function, he has to act on advice. Or could we argue that it falls under the prerogative power, that it falls under discretionary power of the Yang Di-Pertuan Agong. And the prerogative power, just a little bit on prerogative power, it would be another discussion, but I suppose this is something to consider because of the existence of Article 181 of the Federal Constitution that says prerogative and powers of the rulers that they had and enjoyed before the independence shall remain. So what exactly is the prerogative and powers that they have enjoyed before the existence of Federal Constitution that remain unaffected by the Federal Constitution? Lastly, I just want to put a note here that in deciding on this issue, of course, we refer to the Constitution, Federal Constitution. The other one source of the Constitution is the Convention, the accepted practices that the constitutional players consider as binding upon them. And in discussing Constitution, we have to look at the practice of the Constitution. Have to consider the law of power or the real politic, because this involves matters of governing the states. So sometimes that's the real politic on the balance of power between the monarchy and the head of government. Of course, the monarchy have to be, Yang Dutan Agong in particular, have to be careful in using such power to maintain the legitimacy of the head of state. So I suppose I'm exceeding my time, so I'll stop here. Thank you very much.
Thank you very much, Prof. Farid. If I may, just to raise another question that you have already mentioned. In October 2020, there was in fact a request from the government to the Yang Dutan Agong to declare a state of emergency, but it was not granted by the Yang Dutan Agong. But in January, the state of emergency requested by the government was granted. So in that respect, how do you see, the exercise of the power in the light of the various decisions of the court? Even the highest court of the country have decided on this point, on the powers of the Yang Dutan Agong on the proclamation of emergency. I would like your response in a few seconds, and maybe the others will also like to respond. Please, Prof. Farid. Yeah.
Okay, just briefly. One, of course, this area that we have several cases, one way and another, we could say, and is something that's arguable. What is interesting is that if you look just to Article 40, in exercising his function, he has to act on advice. So it seems to be clear, but why it is not clear? That's the issue. Because of course, one, because it mentioned that if the YDPA is satisfied, if the Yang Dutan Agong is satisfied under Article 150, it's not simply on the advice of course, it does not mention, and then of course, then we can look at 1983, 1993 constitutional crisis and so on with the proposed amendment. But still, the provision say YDPA is satisfied. So that's placed an arguable position that it is possible to YDPA to exercise a certain degree of discretion. But before I end, I just like to, again, we always have to refer back to the real politics, because we can't, in a different situation, YDPA may not call to meet his brother rulers. to consider the advice given of the Prime Minister for coordination of emergency. But in 2020, he did do that, and then not the legality, but the legitimacy of it was not questioned because of the situation at the time. So I stop at that. Thank you.
Thank you. Maybe I would like to invite Dr. Khairil if you have any response to the overall or an overview of what Prof. Farid had explained on the powers of the Yang di-Pertuan Agong. I'll give you 1 minute on the overview. Any response to it, please? Dr. Khairil? Yes.
Well, I think looking at the provision of the Constitution, Article 40, it does not exclude the situations apart from the three mentioned under Article 40 that Yang di-Pertuan Agong has discretion. So what are other discretionary power that possessed by Yang di-Pertuan Agong that is up for us to determine. There are actually clearly other provisions or situation where Agong have discretion, not confined to the three situations. And of course, it can also be interpreted that the proclamation of emergency is one of the situation, depending on the circumstances, where Agong may exercise discretion. But overall, we can say that under normal circumstances, Yang di-Pertuan Agong act on advice. So it depends on the circumstances whereby acting as a constitutional monarch, and of course as head of state who's above the politics, he should ensure that the people and the democracy are preserved rather than submitting himself to any interest of a political party or individual. I think that should be enough at the moment.
Okay. I'd like to also invite Dr. Nur Hafiza if you have any response to the main issue here on the population.
Thank you, Prof. Nick. I would agree with my two learned panelists. Looking at the power of the Yang di-Pertuan Agong under Article 40 to act on advice, and I would like also to quote Article 40 Clause 1A, where the Yang di-Pertuan Agong is to act in accordance with advice, on advice, or after considering advice, where the Yang di-Pertuan Agong shall accept in accordance with such advice. So I guess in accepting the advice, the Yang di-Pertuan Agong, I think also not only look at from the just an advice, because it also have the Yang di-Pertuan Agong will also look at other circumstances, other factors, for example, political reality, as what happened in October 2020. That's my comment.
Okay. Thank you very much. So now we are in round 2 of our forum. I would like to invite Associate Professor Dr. Khairil Azmin, who will be speaking on the executive and legislative powers during a state of emergency. Just a brief introduction about Dr. Khairil. He graduated from IIUM in Bachelor of Law, and then Master's Comparative Law from IIUM as well. And his PhD in Constitutional Law from the University of Wales at Aberystwyth. And he specializes in constitutional law and human rights law, and he has written many articles, and he also has been speaking in newspapers, speaking in television and radios on constitutional law issues, as well as being quoted in newspapers on recent issues in constitutional law. So without further delay, I'd like to invite Dr. Khairil Azmin to speak about these particular issues. Yeah.
Okay, thank you very much, Prof. Nick. And then, of course, my colleagues, respected Dean and Prof. Farid, and of course, the head of department, Dr. Nafiza, as well as, of course, our moderator, Dr. Noshada. For my presentation, I would like to use the slide. And I think I have quite a huge task because I have to deal with emergency power, which is quite huge. So please allow me to spend some time to lay down the principles, because I think we cannot really analyze the current constitutional and political conflicts that we have without knowing actually what are the rules that we need to follow. Okay, what actually the basic principles. Now, first of all, we need to know that we are in the state of emergency. So in other words, emergency power is not ordinary power. As you can see that when we are not during the state of emergency, we are using the ordinary norms and we are using the general rules. So this is basically the rules that you have to follow. Now, emergency is only a situation where there is extraordinary hardships. And in these situations, we're going to use extraordinary norms. This is not usual norms, extraordinary norms. So this is why it calls emergency, darurat. So as you know that if you learn Islamic law, there are some things that we cannot use, cannot do. But when we are facing darurat, which is a threat to our life, for instance, we can do things that we cannot do. So this is the emergency norms, exceptional situation. So we are allowed to do things that we're not allowed to do under normal situation. And in other words, we are using extraordinary power or exceptional rules. So this use of power and the application of these exceptional rules are only confined or only subject to certain period, only when there's such hardship, when there is necessity. And as people say, necessity begets. Only when there's hardships, it is justified to use emergency power. Otherwise, it is not. Okay. So when you're talking about emergency power, you're talking about rules which do not comply with ordinary norms, and the use of this power have to be justified. Have to be justified. Okay, now what are the ordinary norms? Okay, so for this purpose, I just would like to I just would like to highlight these are the rules that you have to follow, but under the current situation may be defied or may be breached. Doctrine separation of power, the concept of federalism, and the concept of constitutional supremacy. Now, when we have separation of power, only legislative body can make law, only executive power can administer the country, and only the court can exercise judicial power, and the court have power to judicially review any law and action by the government. So these are the powers vested in three different bodies which act independently of each other. So the executive body cannot exercise legislative power and cannot exercise judicial power. And of course, the legislature can exercise executive power and judicial power, and the rest goes on. So these are basically the rules. And secondly, under normal situation, there is division of power between federal government and state government. So the power to make law can only be exercised by the parliament for the federal government and by the state legislature for the respective states. And for the executive power, the federal government shall be administered by the Prime Minister and the Federal Cabinet, while the state government shall be administered by the Menteri Besar and the State EXCO. And of course, judicial power is vested in judiciary. And when it comes to constitutional supremacy, the parliament cannot make law on which conflicts the constitution. Any law passed after Manekada in consonance with the constitution shall be void. And the court shall have power to review any law made by the parliament or state legislature. So any law which is in consonance with the constitution shall be declared as void. So these are the rules which apply during ordinary situation. Now, why do I need to inform this? Because these are the doctrines or the concept which can be breached, which can be defied under emergency situation. Now, let us move on to the next. Okay, emergency power. And now I'm dealing with emergency power. Now, what actually are the powers which are available during the state of emergency? There are two types of power or two categories of power which are available. First one is the power to make law, and secondly, executive power. Okay, now in brief, for the power to make law, the power can be exercised by Yang Tuan Agong during the state of emergency. Now, this is quite strange, not quite strange, just very strange. Why? Because this is a breach of separation of power. as I mentioned earlier, under ordinary situation, only Parliament can make law for the federal government and only state legislature can make law for the states. But during emergency, Yang Tan Agong is authorized to make law. So there is a breach of doctrine of separation of power. And during emergency, the Parliament can also make law. Now, this is at the first glance, it's not strange because Parliament function is to make law. However, when it comes to emergency, Parliament can make law which are extraordinary. So this is going to be elaborated shortly. And then when it comes to executive power, it is Yang Tan Agong is vested with executive power. So here, as I mentioned earlier, when it comes to ordinary situation, the government is controlled at the federal levels by the Prime Minister and the Federal Cabinet, and at the state level by the Menteri Besar or Chief Minister and the State Council. But during emergency, the power to govern is given to Yang Tan Agong. Okay, so I'm going to tackle one by one. First, emergency power. Okay, emergency power to make law. Now, as I mentioned earlier, the power to make law is given to Yang Tan Agong and Parliament during emergency. Now, I'm going to tackle first Yang Tan Agong, power to make law by Yang Tan Agong. Article 5 Clause 2B is the provision which empowers Agong to make law. However, the power of Agong to make law during emergency is subject to certain restriction. What is the restriction? Except both houses of parliament are sitting concurrently. So when the both houses of parliament sitting concurrently, Agong cannot make law. Now there is perhaps a question, once parliament is convened, let's say the parliament is convened today, it is just an example. Does it mean that Agong no longer empowered to make law under Article 1.5 Clause 150 Clause 2B? The answer is you need to understand the phrase or the word sitting concurrently. Now, what actually the word sitting concurrently means. So when you refer to Article 150 Clause 9, you find that sitting concurrently is being defined. Now, you know that the parliament is divided into several parts. First, parliament life is for 5 years, and within these 5 years maximum, it is divided into session, and then it is divided into meeting. Okay, and then for each meeting there is sitting. So here it does not refer to session or does it refer to meeting, but sitting. So in other words, even parliament convene, Agong still have power to make emergency or promulgate emergency law when the Houses of Parliament are not sitting. Okay, now what are other features of the lawmaking power of Yang Tan Agong? Okay, first, the law is as good as an act of parliament, so it is a good law. Okay, and then it shall continue unless it is being revoked by Yang Tan Agong himself or it is annulled by the parliament. Okay, if the emergency has been terminated, it lapses after 6 months. So this is basically the lifespan of the law, emergency law. Okay, if it is not being either revoked or annulled during the emergency, it is going to still have its life, meaning that it can be enforced, but automatically lapse after 6 months after the end of emergency. Now, another question here is, on what matter can Agong make law? So this is his question. So as you can see that I've underlined the phrase any matter which respect to which parliament has power to make laws. So if we were to understand this phrase or these words literally, it means Yang Tan Agong can only make emergency law on matters which comes under the jurisdiction of the federal government, which is under Article 74 Clause 1, matters which are stated under the federal list and concurrent list. So in other words, Yang Tan Agong can only make law on matters under federal list and concurrent list. This interpretation is a wrong interpretation. Why? Because we have to understand that when we are dealing with emergency, you are dealing with the framework which is special. So we have to understand the meaning of power of parliament within the context of emergency. In order to understand this provision correctly, we need to refer to Article 150 Clause 5. Okay, 150 Clause 5 provides that Parliament may, notwithstanding anything in this Constitution, make law with respect to any matter. So in other words, within the context of emergency, the lawmaking power of Parliament under Article 150 covers everything. So here, in other words, Yang Tanagong also can make law on any matter. What is the conclusion? There is no federalism. Why? Because the Yang Tanagong can make law on any matter. In Yang Tanagong not only have the power to make law on matters under federal list, also state list and supplementary list, which are the exclusive subject matter of Sabah and Sarawak. Furthermore, the law Yang Tanagong can be inconsistent with any provision of the Constitution. So this defies the concept of constitutional supremacy. Because according to the concept of constitutional supremacy as we practice, Article 4 Clause 1 provides that any law passed after Merdeka Day, which is inconsistent with the Constitution, shall be void. So therefore, if Agong makes a law which is inconsistent with the Constitution, it shall be void. But because we have Clause 6 of Article 150, even if the emergency ordinance promulgated by Yang Tanagong inconsistent with the Constitution, it shall remain valid. So far, we can see that they have the three doctrines which I have outlined earlier can be breached. Not, I mean, automatically breached, but can be breached by using the emergency power, which is separation of power, because it's allow Yang Tanagong to make law, and then concept of federalism, because Yang Tanagong have power to make law, not only on matters in the federal list, but also in the state list and residuary matter, as well as the law made by Yang Tanagong can be inconsistent with any provision of the Constitution. So in other words, it's still valid, even it contradicts provision relating to human rights. Okay, so now ordinance promulgated under Clause 2B shall be laid before both houses of Parliament. So this is one of the issues which have been around us. The argument that Parliament must convene in order to pass the ordinance promulgated by Agong. But again, I think this argument is not really tenable. Of course, it has its basis. It needs to be passed, but it needs to be passed if Parliament has been convened. So if there is no Parliament, then the ordinance still good. Why? Because I shall show to you later why. Article 150 Clause 8B, which provides that notwithstanding anything in this Constitution, no court shall have jurisdiction to entertain or determine any application, question, or proceeding in whatever form on any ground regarding the validity of 3. Any ordinance promulgated under Clause 2B, which is the emergency ordinance made by the Yang Tanagong or the continuing enforce such ordinance. So in other words, that argument can be used by politicians, but in reality, in practice, it doesn't bring much weight. Now let us move on to the power of Parliament to make law. The power of Parliament to make law doesn't differ much. It's not much different compared to Yang Tanagong, as said perhaps under a few. Yes.
Can you take just 2 more minutes to complete your presentation?
Okay, I try to wrap up the first part because actually I would like to touch on emergency ordinances made during this pandemic, but let me finish the emergency power, then I wrap up. Okay. Now, during the emergency, Parliament also has power to make law. Then, of course, the one which I referred earlier, the power of Parliament to make law, is not confined to matters in the federal and concurrent list, but also covers all matters available, even it comes under the state jurisdiction or even Sabah Sarawak exclusive power. Okay, and then of course the law also shall be valid even if it is inconsistent with the Constitution based on Clause 6. Okay, so although the power given to Parliament Yang Tan Agong to make law is extremely wide, but there are certain limitations. So the limitations, as mentioned in 6A, is that the power of Parliament to make law cannot deal, the law made by the Parliament cannot deal on matters relating to Islamic law or the Malay custom or the native law custom of Sabah Sarawak. And of course, the power of the Agong and Parliament also does not extend to make any changes relating to the provision of the Constitution relating to religion, citizenship, and language. And of course, the limitation in relation to time, as I mentioned earlier, once emergency is terminated, if the emergency laws have not been annulled or revoked, it shall remain valid only for 6 months. Okay, so lastly on emergency power, executive power. So during the emergency, Yang Tan Agong is given the authority. Commission emergency, executive authority of the Federation shall notwithstanding in its constitution extend to any matter within the legislative authority of a state. So here, when we look at the provision relating to the executive authority of the Federation, it is vested in the Yang di Pertuan Agong. And of course, usually the Yang Tan Agong acts in accordance with the wish of the Prime Minister and the Federal Cabinet. As we can see, what happened in Kelantan, for instance, in 1977, the Yang Tan Agong has acted in accordance with an ordinance passed by Parliament, which empowered the Director General of Government of Kelantan to govern Kelantan instead of the elected members of the state legislature. Okay, so this you can see that the power which being given to the Parliament and state government is very extensive. I think maybe I stop here and perhaps I can continue later. Okay,
thank you. Mr. Khairil. Just a follow-up question to all three panelists. Maybe we start with Dr. Khairil first. Now, when an emergency ordinance is passed during the state of emergency, whether the Agong is acting on his own or he's acting on advice of the cabinet?
Well, I received that question several times. When I say that just look here, use your common sense. Can you draft a law? Well, the lawyer said no. So I say that how do you expect Agong to make a law on his own? So in practice, you cannot expect Agong to make or promulgate ordinance on his own. He's definitely going to act in accordance with advice or opinion of somebody else. Now, making law, promulgating law is not something like writing an article or writing a WhatsApp or blog. It requires expertise, and then more importantly, it must be in accordance with policy and objective. So we cannot say that this is a matter where Agong is going to use as he likes. So again, at the same time, this is the reality. This is the reality. So as we can see, Agong has never used this power without consulting the government. So this is what I can say. Agong has never used the power without consulting the government. And of course, you can see the current Yang Tan Agong, and only he consult the Prime Minister or the elected members, he also consulted the members of the Conference of Rulers. So the idea of consultation and democracy is there. So rather than some sort of trying to give blank check, I think we have to take the reality, understand the reality.
Thank you.
That's my response.
So Hafiza, what's your response to that?
Yeah, I think when we discuss on the role of monarchs in Malaysia, okay, we have to understand that, as mentioned by Prof. Farid just now, that monarchs in Malaysia are not absolute monarchs. They are constitutional monarchs. Hence, I think in all circumstances that the Yang di-Pertuan Agong in this respect has to act on advice, as mentioned in Article 40, Article 40 Clause 1A. And even though during emergency, it has been has been mentioned in several judgments. For example, I would like to quote the case of Teh Cheng Poh and public prosecutor, the case of Madhavan Nair and government of Malaysia, as well as the case of Abdul Ghani Ali and Pendakwa Raya. All these cases shown that though in the during emergency where the Yang di-Pertuan Agong has to act on advice. He does not act alone. He does not has an absolute discretion. Thank you.
Thank you. Prof. Farid, any response to the issue?
Okay, regarding the exercise of power during emergency, I suppose on the face of it, if you look at the provision in the Constitution, if to the simple answer would be we refer back to Article 40 in performance of his function. The Yang Tuan Agong is expected to act on advice of the cabinet or minister acting under the general authority of the cabinet. However, you look at the provision, still it used the language of Article 1501. If he is satisfied, I think so. More rooms are supposed to maneuver there. If he want to use his probably not discretion, his influence in of course, this again I have to say that it has to be used judiciously, because if you exercise too much, if you exercise it in every instances, then probably it would lose its legitimacy. Thank you.
Thank you very much. Okay, so we are now in our third round. We will invite Dr. Nur Hafiza to speak about the parliaments during emergency. Just a bit of a background of Dr. Nur Hafiza. She graduated from IIUM, bachelor degree in law, and then a master's of comparative law from IIUM as well, and then PhD at IIUM as well, and specializes in constitutional law, particularly on citizenship law. And she's currently the head of Department of Civil Law, and she has written a number of papers in newspaper on citizenship law, and also on access to law, if I'm not mistaken. And she also specializing in human rights and law and society. So without further delay, I'd like to invite Dr. Nur Hafiza to speak about Parliament during emergency.
Thank you, respected moderator, Prof. Ahmad Kamal, my fellow colleagues, Prof. Farid, as well as Associate Professor Dr. Khairul Azmin. Okay, before I discuss on the emergency and Parliament, okay, let me pose several questions. I think these are among the questions which has been asked, all right? Why emergency? What is emergency? As what I think mentioned by Dr. Khairul just now, where emergency concerns with the security, economic and public order that cannot be managed under the regular administrative system. That is why we have a proclamation of emergency. Who has power to proclaim emergency? Of course, it differs from one state to another, i.e. From one country to another. And in respect of in the context of our Malaysian constitution, in the context of the federal constitution, as what mentioned in great length just now by Dr. Khairil, where the power derived in Article 150 federal constitution, where it gives the power to the Yang di-Pertuan Agong to proclaim emergency. On what situation, on what grounds? Okay, as mentioned in Article 150 Clause 1 as well as Clause 2, where there are three grounds where if there is a threat to national security or economic life or public order, okay, it does not mean that you must have an actual situation of emergency, but if there is threat, okay, to these three what we call factors, okay, that is national security or economic life or public order, therefore the Yang di-Pertuan Agong has the power to proclaim emergency under Article 150. Okay, before I proceed further in discussing on the current Emergency Essential Power Ordinance 2021, let me just draw attention, especially the younger generations. I guess they are not aware perhaps on the previous or the past emergency proclamations of emergency, because this is not the first time that we have the proclamation of emergency in our country. Way back in September 1964, where we had the proclamation of emergency during the Indonesia-Malaysia confrontation. All right, and then in 1966, where emergency covering state of Sarawak after political squabbles in the state. And I think everyone knew about the May 15, 1969 proclamation after the deadly race riot on May 13. At that time, we could see that policemen and soldiers were deployed and curfews were imposed. So the emergency in 1969 differs from what we are experiencing today. Okay, where of course we do not have curfews, what you call being imposed. And another state of emergency happened in 1977, okay, in Kelantan during a power struggle between the political parties. That was the past history of the emergency declaration. Then what we are experiencing now is the Emergency Essential Power Ordinance 2021, okay, which has been issued by the Yang di-Pertuan Agong under Clause 2B of Article 150, as what mentioned by Dr. Khairil just now. And this emergency takes effect from 11th January 2021 until August 1st, 2021. So this is an extraordinary measures to tackle the surging COVID-19 pandemic. Okay, so the question is that can it be lifted? Yes, of course, it can be lifted earlier. All right, based on based on the advice given by the special committee, where under this ordinance, a special committee was set up to advise the Yang di-Pertuan Agong on the continuance of the grave emergency which threatens the country due to the COVID-19 pandemic. So looking at the ordinance 2021, I think due to time constraint, I will not be able to discuss each and every components of what are contained in this ordinance. But what I can say is that in this ordinance, we could see that the effect of the ordinance is where the constitution would be suspended and the administration of the nation is administered by the executive. And as far as parliamentary sittings is concerned, we know that there is no parliamentary sitting as well as state legislative assembly, where if I may refer to section 14, subsection 1A of the ordinance, which says that provisions relating to summoning, proroguing, and dissolution of parliament to the federal in the federal constitution has been suspended, okay, for so long as the emergency is enforced. However, it is interesting to also draw your attention, okay, to section 14, subsection 1B, as what mentioned by Prof. Farid just now, that the Yang di-Pertuan Agong may summon, prorogue or dissolve parliament on the date where the Yang di-Pertuan Agong thinks appropriate. This, I think, is a debatable issue. How would you interpret what you call the date where the Yang di-Pertuan Agong thinks appropriate? Does that mean the Yang di-Pertuan Agong can exercise his discretionary power? Does that mean the Yang di-Pertuan Agong still has to act on advice referring to Article 40 Clause 1 and Article 40 Clause 1A? So I guess this is what you call, it is quite interesting to debate, open for interpretation. But I guess what I can say is that there should be a consultation between the government and the Yang di-Pertuan Agong, okay, in order to determine what is the what you call the issue with regards to who shall convene. Okay, and then also if you look at the ordinance, in the ordinance it states that the cabinet, the state executive councils, and public services. Okay, so therefore, it is not like what we had experienced in 1969, where we had Magiran at that time. Okay, therefore now, what we are experiencing today under this ordinance is the government and state executive council, public services still continue, okay, to function. And it should be also noted here that the Yang di-Pertuan Agong can make decrees under emergency, such as ordering the government to take over private healthcare facilities to relieve strain on public hospitals, right? And also, in addition, under this ordinance as well, it mentions that the federal executive power covers all provisions under the state legislative powers, with the executive to issue instructions to the state government or any officer or state authority. Okay, now, of course, as I have mentioned, as I've discussed just now, who has power to convene, all right? Of course, if looking at Article 40, Clause 1 and Clause 1A, okay, in exercising constitutional monarch, YDPA has to act on advice. But an interesting, I think, issue is with regards to Section 14, subsection 1B, with regards to the wording when the date where the Yang di-Pertuan Agong thinks appropriate. So I would say that the consultation is important here, okay, between the government and the Yang di-Pertuan Agong. All right, why it is so important that we need to convene the parliament as soon as possible? I think it has been reiterated by the Yang di-Pertuan Agong recently to convene parliament soon as possible. Okay, and then we could see also calls from other sectors, for example, the MPs, even from the government, the oppositions, the political parties, even the public, the people themselves, the rakyat, wants the parliament to convene soon as possible. Now, why is so important that to convene the parliament as soon as possible? Okay, there are several reasons to it. First, I guess this is to allow the proclamation of emergency ordinance, okay, that has been issued to be tabled in Parliament as what stipulated in Article 150, Clause 3. I think Dr. Khairi had mentioned just now, okay, the situation of 150, Clause 3. Therefore, all the ordinances which has been promulgated, okay, need to be tabled before the Parliament. And secondly is that the National Recovery Plan, which has been announced by the Prime Minister, Plan Pemulihan Negara, which was announced by the Prime Minister on 15th of June. Okay, has not been debated by the members of the House of Representatives. Therefore, I think it is important that this National Recovery Plan should be debated by the members of the House. And also, we could see that the economic pressure, okay, due to the pandemic crisis, okay, is still being felt by the people, and it needs to be addressed in Parliament. All right, and also I think that if you look at the emergency proclamation, which allows the government power to greenlight additional expenditure without going through parliamentary approval. So much of the Malaysian COVID-19 policies this year, including its what we call 4-phase exit plan, okay, have not been dealt and discussed in Parliament. And another reason, I guess, is where the MPs need to debate on the 12th Malaysian Plan, 2021-2025, as it contains a policy framework and the allocation of resources for national development. So based on this, these are among the reasons. Perhaps others, there are other reasons, but these are among, I think, the crucial reasons why the Parliament need to convene as soon as possible. Okay, in discussing on whether in discussing on the issue of convening the parliament. So of course the question is how to convene the parliament during this pandemic. Okay, how to roll it out. It has been suggested that there should be a hybrid form of parliament. Okay, this was I think even suggested by members of the parliaments themselves. And if you look at the statement given on 25th of June by the Senate President as well as the House of Representatives Speaker, where they said that a special steering committee set by the Parliament Office has looked into the technologies and methodologies which required for hybrid proceedings. I think that's all I can share, Prof. Nick.
Okay, thank you very much, Dr. Hafiza. We are already past 9 p.m. And I believe that it's a time for question and answers that our audience are probably wants to ask. But before I invite those questions from the audience, may I just remind the audience that to put here to mention your names and your affiliations, and please make the question brief, and I hope also the panelists also answer briefly so that we can have more questions before we end at 9:30. So without further delay, I would like to invite members of the audience to raise questions. You just switch on your microphone and if possible also your videos and ask questions, please.
All right. Assalamualaikum.
Salam.
Questions? All right. Okay. Assalamualaikum to all my respective lecturers. I'm happy to see all of you here. All right. I'm Nur Hidayah. I would like to ask one question. Yeah. Today is how do we balance the power of constitutions and the economics and social needs of the people in lieu of the pandemic of COVID-19? So how do we move forward? That's my question. Thank you so much.
Okay, we ask Prof. Farid to answer that question because Nur Hidayah has not asked which panelists want to answer. But I will ask Prof. Farid to answer, and then maybe the others may also want to add that.
Thank you for the question, but I have to seek clarification first. How to assess? I didn't get.
Hi, Prof. Good
Yeah.
to see you again. Yeah. All right. Okay, my question is, how do we balance power of constitutions and the economics and social needs of the people in the lieu of the COVID-19? How do we move forward?
Okay, I'm not really sure what you are trying to get at by the question to balance between the constitutional power. What do you mean by the constitutional power? The power of the Yang di-Pertuan Agong, the power of the Prime Minister, or the power under the during the emergency? I suppose you are referring to the power.
Yes.
Okay. As I think as described by Dr. Khairul Azmin, that you have the normalcy situation, you have the emergency situation. The Constitution provide under Article 5150 to deal with grave emergency, and there is special powers under that, from promulgation of laws, inconsistent with the Constitution, transgressing the limits of federalism, transgressing the limits of executive and legislature in particular, and so on. So abnormal situation requires abnormal remedy. But of course, the issue is there should be the question of necessity and the question of proportionality. So if indeed there is necessity, then certainly there is the Constitution provide for a way out or a way dealing with the necessity. So, question of balance. So for me, you look at the necessity. Is it necessary to have emergency? Is it necessary to exercise those powers? Is it necessary to have those special arrangement? So one question of necessity. Second, proportionality. Is the extreme exercise of the power is proportionate to the degree of emergency that you have? Because even the constitution itself envisage the degree of the necessity or degree of emergency. So if you can answer that question, necessity and proportionality, then you have the constitution that provide for the abnormality of the situation. But if you don't have the necessity, or you exceed, you breach the proportionality, then there's no balance anymore. Thank you.
Okay, Dr. Khairul and Dr. Hafiz, any response to that, please?
Well, just briefly, in emergency, if you go to hospital, there is what's an emergency ward. So when we're dealing with emergency, you are dealing with something which is unplanned, and we have to use very extreme measures. So now, let's say that you are a doctor, and then somebody have diabetic and has a gangrene, let's say feet. Now, if you don't cut, for instance, one of the you do not cut the feet, and then the person shall die. So you don't have any choice but to cut the feet in order to preserve life. So under the current situation, under the situation of emergency, we have to take drastic measures. Of course, we want this to be as short as possible and as swift and brief as possible. But again, so this is, I think, one of the issues here, why there's so wide power but the achievement is so low. This is the issue. The question of the ability to use the power necessarily and effectively. And of course, again, I think I agree with Prof. Farid said, well, it is emergency is proclaimed if there is necessity. If it is not necessary, why do you proclaim emergency? Emergency is only proclaimed if you want to use the power. If you do not need emergency power, there is no need to proclaim emergency, because emergency is going to bring negative effect to the image of the country. And of course, when we are dealing with emergency, I believe the government have to be brave and bold, and not acting hesitantly or not fully utilize the power, because we want to make it as short as possible. I think that's my brief comment.
Dr. Fiza, any additions to that?
Just a brief one. I think in response to Prof. Farid's answer with regards to how you balance between the need, the economic as well as the constitution, okay, where you also have, on one hand, you are giving the power, all right, I would say excessively, okay, during emergency. On the other hand, you have to also look whether it is proportionate. Therefore, that is the reason why I think the parliament need to reconvene, need to convene as soon as possible, okay, so that the emergency proclamation, which allows the government's power to green light additional spending, okay, without going through parliament's approval, I think should be brought before the parliament for the members of parliament to debate on this. All right, that is my comment.
Okay, we have a question from Brother Lokman, and then we have from Brother Khalid Ansari, and also from Daniel Farhan. Would like to invite Lokman first. Yes, please, Lokman.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Very good evening to all my friends and colleagues. My name is Lokman. I'm from I'm one of the alumni. I think this current constitutional issue poses a number of interesting questions. I think what we are clear, if you don't mind, just a little bit especially before I ask question. One, it is clear in December, despite the advice of the government, the Agong uses his discretion not to continue with the emergency. We know that Teh Cheng Po is actually under 150. You must exercise, Agong must exercise this his power according to the advice of the executive. Currently, going forward, whether to extend or not the emergency, the government, there is a possibility the government may want to extend the emergency, but the Pertuan Agong may not want to extend the emergency, right? And whether the sitting of the parliament, Agong has discretion to call for summons. I think that has been dealt with. Now, let's take a hypothetical question. We need to find a jurisprudential basis on this. I think on one hand, we do not, let's take Malaysia out because we need to have a consistent position. On one hand, we do not want an executive to use emergency, right, to extend its power without the majority, right? On one hand, we do not want Yang di-Pertuan Agong to exercise emergency without consultation of the government, right? Now, what is legal jurisprudential basis that we should hold on to be consistent in all scenarios, right? Otherwise, this is a conflict we will pursue. If we insist at all time, Agong must actually follow the executive, what will happen is actually there can be a position whereby the executive will want to continue its power by using emergency and Agong does not have discretion. Right? So where is this jurisprudential basis that we should really rely on? That is one. Secondly, probably we need to look after Teh Cheng Po, the issue of satisfaction in exercising Article 150. Now, under Article 150, Teh Cheng Po, we know that Teh Cheng Po says it must be in accordance with the executive, right? But probably how many times have the word satisfaction been used in the Constitution? Are there any other articles, and how has it been interpreted? Or should we now re-look into a totally different jurisprudential basis? Okay, that's all my question. Thank you.
Okay,
thank you, Prof.
Yeah, thank you, Dr. I would like Dr. Khairul to answer first.
Okay, actually there are a lot of questions there, and then the questions are not all easy questions. First of all, when we look at the emergency provision, emergency power, once emergency is declared, doesn't mean that Agong can do whatever he likes, or it doesn't mean that Parliament can make whatever law they like. First of all, it must be authorized. It must be authorized. In other words, let's say that if Agong would like to do something, then it must pass a law and promulgate ordinance, or Parliament must allow authorizing Agong to do something. Okay, so this is basically the procedure. So in other words, once emergency proclaimed, it doesn't give a blank check either to Agong acting its discretion or Agong acting advice to do or to become like a dictator. No, it doesn't work like that. There must be law promulgated or passed by Parliament which give the Agong or the either acting on behalf of the Prime Minister to do anything. So that is one thing we need to be clear. And secondly, when it comes to summoning the Parliament, I think when you look at the provision of the ordinance, especially I think section 18, which provides that in the event of any conflict or inconsistency between the provision of this ordinance and any other written law, the provision of this ordinance shall prevail, and the conflicting or concerned provision of such written law shall be deemed to be superseded to the extent of the conflict or constituency. So the word used there is written law. When you look at the Constitution, the word written law covers the Constitution and law passed by a federal law. So in other words, if we will to understand that it allows Agong to summon Parliament on the date that he thinks fit, that argument is tenable. And I don't have problem if Agong summon Parliament in his discretion. That is power that he can rely on the provision. And acting on this power, he is acting in accordance with democracy. So in other words, it doesn't mean that whenever we give discretion to Agong, he's going to go against the idea of democracy. In other words, he is preserving democracy. If, let's say, summon parliament, he is using his discretionary power to preserve democracy. Because without the parliament, then the executive is not accountable to anybody. This is the power which I questioned at the very beginning when the ordinance was promulgated on 11th of January. I basically have no problem with other powers. When it comes to suspension of parliament and state legislature, that basically struck me quite hard. Why there is a need to suspend the state legislature? Why there is a need to suspend parliament? Because when we look at other countries, countries which have higher infection than us, they did not. Some countries did not proclaim emergency, and even countries which proclaim emergency, they did not suspend their parliament, but we suspend our parliament. So this actually is creating more trouble to the government rather than helping the government, because the question of legitimacy, the question of accountability begets the government. So I think it doesn't work in their favor, but against their favor. So again, as we have seen that the line taken by majority, or in fact by the Attorney General, is that Agong have to act on advice. And the way I see it, Agong has always been somebody who act not against the current or doesn't want to rock the boat. So he doesn't want simply to use whatever power available to him, but he exercises it sparingly. Okay, so the way I said, when it comes to discretionary power and of Agong, the discretionary power of Agong is to preserve democracy and to for the welfare of the people, because that's what it is. Agong as the head of the state. Now the thing is, if Agong were to turn this country into absolute monarchy, first of all, they can do that before we get independence. Simply refuse to allow the country to become the monarchic country and would like it to be an absolute monarchy. That they can do much earlier. And secondly, the opportunity came in 1969 when there is no government because the election has yet to finish. So this is again a situation where the monarch have the opportunity to turn the country into whatever they like, but they did not use it. So here we have to place a trust on the rulers. We have to place a trust on the rulers, because the rulers so far have never abused their power to make this country into an absolute monarchy, to do whatever they like. But they try to, to the extent that possible, to make it something which is acceptable and for the welfare and the benefit of the people.
Thank you. Okay, I would like to invite Mr. Khalid. Mr. Khalid, are you still there? You have already raised your hand to ask questions.
Yeah, sure. Thank you very much, Prof. Farid and Prof. Khairul, Prof. Abdul Hafiza, for organizing such important talk. So my question is about, it's not directly actually about emergency. It's about the appointment of present Prime Minister, by young Putrang Agong, and the position of the Constitution of Malaysia, because that should be, appointment should be by the Parliament, right? So how do you think, how do you look this appointment, under the Constitution of Malaysia? Thank you very much.
Thank you for the question. I would like to invite Dr. Nohafiza to answer the question. The appointment of the Prime Minister.
Thank you, Mr. Moderator. Thank you to Prof. Ahmad Kamal. Okay, in response to the question on the appointment of a Prime Minister, I would like to draw your attention to Article 43 Federal Constitution, where it says that the Yang di-Pertuan Agong shall appoint a Jemaah Menteri or a cabinet, of ministers to advise him the exercise of his function. So from this we look where we could see that the Yang di-Pertuan Agong is a constitutional monarch, where he appoints the cabinet to advise him in exercise of his function. And in response to your question, okay, in Article 43, Clause 2, where it says that the cabinet shall be appointed, okay, by the Yang di-Pertuan Agong first, where the Yang di-Pertuan Agong shall appoint a Prime Minister to preside over the cabinet, a member of the House of Representatives, who in his judgment is likely to command confidence of the majority of the members of that house. This is clear, okay, with regards to the appointment of the Yang di-Pertuan Agong. Though I would say that the appointment of the appointment of Prime Minister is one of the discretionary power possessed by the Yang di-Pertuan Agong under Article 40 Clause 2A. However, again, back to the function of the Yang di-Pertuan Agong as a constitutional monarch, as what Dr. Khairil mentioned, okay, does not mean that the Yang di-Pertuan Agong can exercise his power, okay, as he wishes, absolute power. It has to be exercised in light of the constitution, even though it is within his discretionary power, because as what mentioned in Article 43 Clause 2A, that the Prime Minister is appointed by Yang di-Pertuan Agong among members of House of Representatives who in his opinion here is referring to the, in his judgment here is referring to the judgment of the Yang di-Pertuan Agong, that particular person command the confidence of the majority, okay, of the members of House of Representatives. So I think that is clear as far as the constitution is concerned. Perhaps one might ask a question on how to demonstrate loss of confidence, or how would you know that the person had the Prime Minister had lost confidence. Of course, we have to refer to various judgment which has been decided by the court as how to demonstrate loss of confidence. If you look at the judgment in Datuk Sri Nizar Jamaluddin and Datuk Sri Zamri Kadi, where loss of confidence could be demonstrated not only through formal voting, it could be done through extraneous circumstances. So I guess, of course, this I'm going further with regards to what you call demonstrating loss of confidence, because there were talks out there saying that is there what you call suggestion, perhaps when the parliament convene, and there would be loss of confidence of the Prime Minister. So of course, how to demonstrate loss of confidence, it is not necessarily to be done through formal voting. If you refer to the previous decision in Datuk Sri Nizar Jamaluddin and Datuk Sri Zamri Kadi, it could be done through extraneous circumstances. That's all.
Thank you. It's close to 9:30, but we can just add another 10 minutes or so. I think we allow Daniel to ask questions first, and then Lokman Hakim.
Okay, Assalamualaikum to my fellow lecturers. My name is Daniel, one of the alumni. So my question is, does the findings in the meeting of the Conference of Rulers plays a massive role to the executive body pertaining on any current issues? And does it give any influence to the government? Thank you.
Thank you. So Prof. Farid will answer this question. Please, Prof. Farid.
Thank you. Whether the finding or the opinion of Conference of Rulers would have any value to the government, if I get the question correctly, Brother Daniel.
Yes, that's a question.
Yeah. Okay. So the I suppose the short answer is yes, because Conference of Rulers is an important body that's involved, that have its role in the executive, in the legislature and judiciary, similar to the Yang di-Pertuan Agong. Of course, it's also involved in the election of Yang di-Pertuan Agong, or there's any question on removal of Yang di-Pertuan Agong. So it is an important body, and if the question is whether it has any value or any bearing to the government, and I suppose the answer is yes.
Okay, all right. I'd like to invite Brother Luqman Hakim to ask a question, please.
All right. Thank you very much, professors and respected lecturers. Assalamualaikum. My name is Luqman Hakim, and I am an MCL student, postgraduate. So my question is, with the recent news that the Yang di-Pertuan Agong has instructed the Prime Minister to convene a parliament before 1st of August, if I'm not mistaken, and what happened if the Prime Minister refused or stubborn to comply with such instruction? Because to my knowledge, the Agong can only have the power to appoint the Prime Minister, but can the Agong actually sack the Prime Minister, since the nature of our monarchy is a constitutional one and not an absolute? If absolute, perhaps can easily sack the Prime Minister. And what other possibilities can the Agong do in the case of the Prime Minister himself stubborn to reconvene the Parliament? Thank you.
Okay. This question to Dr. Khairil.
Okay, there are several questions there. First of all, relating to the titah by Agong to summon the Parliament. Then secondly, I think the question relating to removal of the Prime Minister. Okay, so this is actually a very serious question. Okay, first of all, relating to summoning the Parliament. Okay, as we can see that the Yang di-Pertuan Agong has agreed to have an audience with the Speaker of the Dewan Rakyat and the President of Dewan Negara. And then actually the both speakers, Dewan Rakyat and Dewan Negara, the Speaker and the President, have issued a statement whereby they have submitted the titah or the decree of the opinion of the Agong to the Prime Minister, so as to have the Parliament convened before 1st of August. Okay, so now you can see that the wordings there are very diplomatic. You know, wordings are very diplomatic. So the king did not say that you must convene, but the king basically conveyed the message that he feels that it can be done. Okay, so this is basically the beauty of the Malay adab or sopan santun, as we see. Basically, you basically are not going to be abrasive. Legal, constitutional is something that you can go to court, and sometimes you're not worried about whether it's legal or illegal, but you're more worried of its political consequences. So this is basically the one that the politicians are really worried, because if you do something which is legal but it is not politically correct, it's going to be damaging. This is where the people assess you. This is the people will know what you're made of, what the leader made of. So it is not necessary for the king to give a decree, you must do this, you must do that. Simply they say that it should be done in this manner. And I just would like to reiterate that after the proclamation of emergency in January, Agong has issued a statement, I think in February, saying that when there is emergency, it doesn't mean that the Parliament is going to be suspended indefinitely until the end of emergency. So if you understand from what the statement made by Yang di-Pertuan Agong, it means that Agong will have no issue if the Parliament is being called for session. So and again, I think when we are coming towards the end. Now earlier, I have perhaps I feel there's justification for the Parliament to be suspended in order for the safety of the members of Parliament to be safeguarded. But that is before we found vaccine and before the members of Parliament be vaccinated. And in fact, by now, I'm very happy if Parliament done in hybrid, whereby everybody in Malaysia can see how members of Parliament works online, live. Why? It is not impossible to have online Parliament session. Why do you want what do you want to hide? We can have our session live today. Everybody can join. Why don't you have Parliament live in session before 1st August. It is not impossible. So I think this is where the government have to think, you know, whether they are going to accede to the request, because the thing is, they are worried that perhaps, I think this issue, Prof. Khalid, Dr. Khalid as asked earlier, Dr. Nafizah, as in relation to the appointment of the current Prime Minister. Well, in my opinion, it is valid appointment, then the current Prime Minister is a legitimate Prime Minister. But the thing is that a lot of people say there's worry on the behalf of government that if they convene parliament, they could lose the confidence of motion of no comment could be tabled and the government could fall. This is basically, they say, the reason why emergency is proclaimed in the first place, to suspend parliament in order to prolong a government which have a rather thin majority. Now the thing is, if the government has done good, they need not to worry about the support in parliament. See, so this is basically this is where I think the Yang Tuan Agong and the speakers have shown their maturity. You know, you something need not to say something, but it is very obvious. Okay, and basically we let the people who have the power to do so to think what is good for them and what is not really good for them. Okay, because, well, you know that it is, in the end, it is the people who shall decide.
Okay.
Okay.
So we have questions in the call messages. Let me, there are 3 questions here. Question from Anif Rafi, asking about the whether the emergency proclamation and the ordinance may be challenged in court. I think that one is a very academic question. I think recently the High Court's already rejected this challenge in court. But there is this question from Mustaqim Huzaini, who asked about whether the government can be held liable for the loss of life those who committed suicide during this MCO period. A very interesting question. Anyone like to answer this? I'll give your view on this point. Anyone from the members of the
I think in law you cannot directly blame the government, you know, because this is where we refer to criminal law. The criminal law. If you want to blame the government, are you going to blame the whole government or only certain? There must be certain person responsible, isn't it? So I think so far, perhaps if you see that if issues like ethnic cleansing, war crimes, then government can be made responsible, but there must be chain of authority. So in this regard, I think it is not possible to bring action against the government for loss of life for people committing suicide. But again, although the answer is not legally, the answer is not legal, but what matters is there is political repercussion. So maybe that is the avenue. That is the avenue.
Okay, there's a question here from Farhan Rosli. What is the effect when emergency bill tabled before 1st of August in Parliament and the bill has been rejected, the majority of the MP? Prof Farid, want to answer very quickly? What is the
emergency bill?
Yes,
emergency building.
What if the bill is tabled and then rejected by the members of Parliament, by the majority?
To affirm the emergency, what?
Yes, the emergency proclamation and also
maybe if I can help this one.
Yes.
Yeah, please.
Okay, I think this is relating to as when we look at the provision, the emergency proclamation and emergency ordinance have to be tabled before the House. Okay, so it's either being revoked or annulled. So if it is annulled, then the proclamation shall be terminated. It doesn't have retrospective effect. It's going to be terminated on the day it is annulled by the Parliament. Okay, but the thing is, you cannot bring it to court because it is an ordinance promulgated. And I think, as mentioned earlier, under 150 clause 8, the court cannot hear any cases in relation to the validity of any ordinance promulgated under Article 150 clause 2b.
Okay.
I the answer.
Yeah. Okay. There's a question here from Ziaoni Charutni, who asked a question whether the government can impose mandatory vaccination using ordinance.
That I think is possible because if it is made under ordinance, as we have seen, it can be contrary to any provision of the Constitution. And in this case, I think Article 5 relating to personal liberty, the body of the person.
Yes.
Okay, so here, by using the immunization ordinance, I think it is possible for the government to make such law. But I think the government is not going to make such law because it's going to have political repercussion. So this is where I think what the government, not Malaysia but other countries have done, they make a condition. If you want to enter our country or you want to go somewhere, you have to be vaccinated. You must have certification. So in other words, they don't say that you must vaccinate, you must get vaccine. But in other words, that well, you don't get vaccine, then you cannot do this. So in other words, it is it compel them whether they like it or not to being vaccinated rather than making a law.
Okay, so we have come to the last question. We don't have any more time to extend. Okay, Brother Muhammad Zahidul will ask the last questions. Yes, please.
Okay, Assalamualaikum, Prof. Just for my curiosity, just I want to know, we understand the present situation, the government situation, the ruler from the council. Few days earlier, I saw in the newspaper there is a meeting with the Yang Di-Pertuan Agong, and they said that we want a stable government. So without election, how we can establish a stable government in this situation?
Dr. Nafiza, your views on this?
Well, of course, if you refer to the ordinance, okay, where there should be no election under the ordinance, but perhaps later on, when the parliament has been convened, perhaps we could have election after this, because you know that the election period would be the parliament, the term of parliament is 5 years. It could be lesser than that, okay, as well as state legislative assembly. So it all depends on the head of state as well as the state government, and at federal level depends on the government and also the Yang di-Pertuan Agong.
Okay, all right. So since that's the last question, I would like the panelists, I'm giving you 2 seconds, each of you 2 seconds to conclude from your point of view of the overall discussion that we had. Starting with Prof. Farid.
2 seconds, okay, 2 seconds. Okay, I suppose we relate to, we have been discussing about Yang di-Pertuan Agong. So that's where the principle is on the Yang di-Pertuan Agong being the constitutional monarch. What I would like to leave us with, referring also to Brother Lokman's question and others also. Yeah, as lawyers, we are always search for certainty, vying for certainty. But in this situation, particularly for constitution, fuzziness has its value. That's all. Thank you.
Thank you. Dr. Khairid, very quickly.
We need to look at the circumstances because sometimes the rules changes due to circumstances. So we need to use case by case basis as well. We have a general rule, and some situation we need to address case by case basis. In this situation, I think we need to use case by case basis. Thank you.
Thank you. And finally, Dr. Nur Hafizah.
Okay, I guess my conclusion would be on way forward on the hybrid parliament. I think Malaysia could emulate other countries that have improvised how their parliament continue the business of lawmaking even at the height of the pandemic. And in particular, I think we can learn the British Parliament, where they began hybrid sitting back in April 2020 by observing social distancing of at least 2 meters in the chambers, and the rest connecting via Zoom from their homes. So I guess my last word is that if there is political will on the part of the government, we have the technical capabilities to conduct hybrid sittings, and the legal obstacles can be overcome through amendment to existing laws and standing orders. Thank you.
Thank you very much, panelists. That marks the end of the session. Alhamdulillah. Thank you, my lovely, my very convincing arguments that was raised by our panel members. And also, I'd like to thank the organizers for organizing this. And I hope that it benefits all the audience tonight. And I'd like to thank everyone. Again, we thanks to Allah for His Taufiq and Hidayah. And I would like to pass this to Dr. Nur Syahadawati.
Okay, Assalamualaikum. Thank you, Prof. Nick, for the conclusion for this program. I would like to thank you, everyone, especially the panelists and moderator, for the very informative and very interesting discussion that we had today. I was actually attracted to the question asked by one of the audience here when the person asking whether the government, can be responsible for the number of suicide that's happening right now. I would like to bring your attention to what happened in South Korea with regards to the Sewol boat sinking. There was a boat that was sinking, and when they are en route to Jeju Island, if I'm not mistaken, and the boat actually sank. And they waited for 3 hours for the help to arrive, but it didn't. So they actually blamed the government, and it was but the court actually decided, they ruled that the government was responsible for the delay. And I think it would somehow would be relatable to the question that you have now. Just something that just came up to my mind when the question was asked. But anyways, I thank you I thank everyone for their participation throughout this roundtable discussion, and I hope that everyone enjoyed the program. And before we end, can we just take a moment to take a photo? It's like a photo session. So to basically hope that this perhaps later we're going to have the more roundtable discussion will come after this lah, inshallah. So perhaps everyone can be ready for photo session, and turn on your camera. Other than this, our audience, just panelists and moderator. Other than that, can everyone just for a 5-second photo session. Perhaps Dr. Zahidul, can you?
Yeah.
I hope that everyone can be ready. So perhaps Dr. Zahidul, you can start counting. So everyone, can just look at the screen.
Okay, 1 minute. Okay, 1, 2, 3. Done.
Okay, thank you so much to all of you for joining this program. I hope that you can we will meet again, inshallah. And before we end, let's recite Tasbih Kifarah and Suratul As. Alright, thank you. With that, have a good night. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum.
Thank you, Prof. Thank you, Dokter.
Thank you, everyone.
Thank you, Prof.
Prof Nick tak kasih saya tanya.
Sorry, Dr. Iqbal.
We need a special session for Dr. Iqbal.
I think it's just the name to Dr. Iqbal, and I will
Thank you very much. Very interesting. It's very fruitful. Thank you very much. Thank you.
Waalaikumsalam.
Thank you, sir. Thank you, madam.